Thank you for listening to The Well. Our theme tune is Love the Government by El Papa Giraffe and is licensed under Creative Commons. You can follow us on iTunes or your preferred podcast app.
Hello Heidi, thank you for being with us today. So firstly, what I'd like to talk to you about is, well, you're a professor of law and international relations, is that right?
Just law.
Just law. With an interest in international relations, I guess, yeah?
I mean, so I do international law, which we generally tend to think of as actually quite distinct from international relations.
Okay.
In the sense that IR doesn't address itself to law very much.
Okay.
So yeah, no, I'm a professor of law. My research focus has historically been international law and conflict focused. Yeah.
And that's you work at York University, which is in Canada, right?
Yeah. So I'm at Osgoode Hall Law School, which is located at York University in Toronto.
Okay, so that's perhaps a good place to start then. I'm just interested in getting your views generally on how you conceive of the idea of law. I mean, what is that for you? What does it evoke for you when I say the word law?
I've been trying to reimagine how I may have once thought about this, as a first year law student. And I have no idea. So it's hard to track how things have changed in some sense. What I'm trying to say is that so people will hear this. I'm trying to stave off the reaction I get from my first year students when I come into class and it's their first international law class. And I say, well, law is just something we make up as we go along. And then they're like looking at you like, why are we in here?
Right. Well,
and you're here because you're here for training to enter the international elite ruling class, basically.
You're a gatekeeper for the elites.
Yeah. No, but it's true. I mean, that's what law schools do.
So are you saying that that law is, well, the general preconception of what law is and laws?
So what do you think law is as of?
Okay. It's okay. Well, I'm not a philosopher of law, but I've got a kind of a passing interest in jurisprudence.
Right.
As you do. I guess I kind of see it in a sort of a conventional sense. I see it in a very sort of contingent sense that, law is, I mean, I guess that's what your students are saying, right? That law is something laws are immutable. There's something ahistorical. To me, I did my sort of doctoral research on Derrida and kind of one of his ethics and that kind of stuff. And one of his big essays is Force of Law, which I'm sure you're familiar with. Mm-hmm. And kind of in that, he kind of argues that law is, I guess, it's something constructed.
Oh, absolutely. Yeah. So Derrida is very important too. So I would operate in the strain of critical legal studies, which is basically, we're just deconstructing it.
Just deconstruct it.
Yeah.
I was recently reading a book. I don't know how to pronounce the guy's name. It's called The Play Element in Culture. It's like a book from the sort of 50s and 60s. It's by a chap called Johann Huizinga, I'm going to call him.
Okay.
But he's basically got the thesis that the idea that play is the predominant notion behind all culture. And in that, he looks at the construction of legality, and he sees that as something kind of, as a he puts it inside what he calls the magic circle, which is what he means by that, I think, is a demarcated space where you have contestants. And you can see that the law is kind of like that, it's got a sense of the theatrical. There's a sense of fictionality about it. There's a sense that there has to be winners and losers. Mm-hmm. And in that regard, then that's I guess how I conceive of it. Is that something that chimes with your thoughts on it, or where you currently are at?
Yeah, absolutely. So of course, so I would say this is a very unorthodox, so I consider myself part of a group of people. I mean, we call ourselves heterodox thinkers about law, which, and so in other words, so everything you've just articulated, I'm very comfortable with, and would take on board unproblematically, but to situate that within the sort of a self-understanding of the discipline, which is simultaneously a profession in most instances, right? That's a very, very, that's not a popular attitude to take.
Why is it not?
It's well, I mean, for many reasons. I mean, it's not popular because it challenged. So I was laughing, but I was serious when at the beginning of our conversation when I said, look, law school is about training for hierarchy. And this goes back. If people are interested in this stuff, they can read Duncan Kennedy at Harvard Law School's early 1980s piece on legal education as training for hierarchy and domination. And because this, so recognizing you said law is conventional, it's contingent. You said there's a sense in which it's ahistorical, or it's some kind of sort of cultural, more or less not arbitrary may not be the right word, but highly fluid and often arbitrary cultural artifact. And also an aspect of culture, which I think is hugely important, right? Because there's often a sense that law should be placed outside of culture or in relation to it in some way, as opposed to being a cultural artifact. But people are uncomfortable with that because that makes it difficult to train for hierarchy. Right. So
right.
That's why it's uncomfortable. It's uncomfortable for the profession. It's uncomfortable for Judge Kavanaugh. It's uncomfortable for the higher echelons of the hierarchy of the legal and political system. Because law is also just a branch of government, right?
Right. Yeah. I mean, yes. Well, it's essentially an institution.
Yes, absolutely. Yeah. Yeah, sure.
And I guess in a sort of a political sense, then, do you think that law is something that reproduces hierarchy? That's its function. Absolutely.
It reproduces it and re-inaugurates it in different modes. In that sense, it is historical because so wonderful historical people who work from some kind of roughly historical methodology will be able to explain just different aspects of law's functionality in relationship to the way in which domestic or global power is being exercised in X, Y, or Z scenario at a given point in time.
You're comfortable with, I guess, sort of postmodern interpretations of law. And by that I mean, thinkers like, like we mentioned, Derrida, Foucault, Lyotard, these type of thinkers.
Well, I wouldn't say that. Can I reformulate that? So I would say I'm not, it's not that I'm comfortable with their approach to law, which often is flawed. I would say, part of what we're doing as legal scholars, right? And, which is funny because like law, as I said, law is, like you said, law is an institution. So it's funny to then translate it into some kind of scholarly field. It is actually. But what we do is sort of do our own take. And there are different, some people are straight up Marxist, some people are more postmodern, whatever, but it's not that we're taking on board Foucault as such, but more, doing our own thing with a more precise and differentiated appreciation of actually how law works, because those people don't really have a good understanding of that.
Okay, so I'm wondering then. I mean, I guess the accusations that's holding on to those caveats that you mentioned. What is your take then on, say, what people accuse sort of the postmodern theorists of, or say postmodern understandings of law? And the usual accusation is that it leads to both moral relativism and epistemological relativism. That's
right.
That the law should be about it may be fictional and it may be theatrical, but it has very real effects. I mean, it has so like if you're on death row and you're wrongly accused, it's hard to kind of sort of postmodernize that away.
So that's a great question, because I think there are two kinds of accusations, and they're different, right? Accusations against people who take some kind of postmodern or like generally leftist approach to to the study of law. So one is this, so someone who's made a claim of moral relativism in the sense that that would facilitate some kind of obfuscation or ignorance towards the material or real, as you said, effects of law, hasn't engaged with critical legal scholarship.
So they're getting it wrong, basically.
Well, they haven't read it. Or if they've read it, they are dumb. So the thing is that, no, I'm sorry, it's true though, but it's not to put too fine a point on it, but the thing is, because the point of the postmodern, I was about to say the postmodern term and I thought that's ridiculous. The point of critical legal studies as a methodology of studying and operating within the power structure that is the law is precisely to be able to more clearly articulate from a distributive material sense what actually the impacts, not just in some kind of like, let's go out and do, analytic research and measure impacts and that kind of thing, but to figure out, like, concretely who are the winners and losers, and that from a political sense as well, and what are the stakes, what are the costs and benefits, why are we doing this? And so the idea is, I think, so in other words, the method is not undergirded in any sense by some kind of conviction that we shouldn't be using law to affect more appropriate outcomes in society. It's asking us to realize that in order to be able to affect those outcomes and to more usefully leverage the law as a tool of either strategy or tactics in a concrete political fight, you need to understand the, let's say, constructivist nature of law as shorthand, for example.
I think I follow you. So what you're saying is that, I guess, what sort of separates your thinking from, say, an out-and-out postmodernist, where everything is constructed, everything is, just interpretation upon interpretation. You're saying that we can have that, but we also need to attend to, well, real concrete outcomes of legal cases, or the materiality, as you say, of it. So, that laws can make society better or can make society worse in a real objective sense.
No, absolutely. And I mean, that is that might be a general explanation for why people in my sort of camp, or for lack of a better word, are frustrated with postmodern thinkers themselves. It's because they don't understand law, like they don't concretely, really structurally understand how the institutions work in society, that they're not able to understand the way in which, law enforces indeterminacy, basicay. Right.
Okay.
So
law enforces indeterminacy.
Yeah. So it's an enforcement tool. Yeah. So they've established, Derrida, whoever has established that it's all constructed and relative, and we've taken that on board. But we understand that legal doctrines, a given legal doctrine, would be constructed by actual people with actual political projects in actual governments or municipalities or the United Nations or whatever, right? Trying to make their political projects real in the world through the leveraging of legal structures, right? So so in other words, none of it's accidental. So so that's why arbitrary is not such a great word, because the constructed nature of law is not accidental. It's there to serve purposes, and those purposes are served, as you said, by sometimes putting people in jail, or garnishing their assets or whatever, right? In other words, there's a concrete enforcement there.
Sure, absolutely, there is. Yeah, I mean, it's called prison. Yeah.
Yeah. Well, prison in the worst. Yes, prison in the worst sense. Sometimes, capital punishment as well. But yeah, that's why I think as well, people, and in particular, like any students of law and other scholars who think deeply about this stuff, that is partly why they're uncomfortable. It makes people very uncomfortable to realize that we're putting people in prison for no reason. That means no good reason. In other words, it's very difficult to come up with a fully defensible reason.
Could you give us an example, do you think, to help?
Well, I mean, I tend to think I'm a bit of an extremist from a criminal law perspective. I'm sort of I'm saying this like facetiously right now, but you know how there are all these like abolitionists, like prison abolitionists and stuff. I mean, I agree with the project in the sense that I don't think we should have criminal law is not a useful way of managing social issues. It never helps.
Right. I mean, yeah. I mean, that's one of the sort of that's a very common shorthand, isn't it? People say you can't legislate morality. I mean, for example, like the Volstead Act or something like prohibition. You can't just legislate people into not drinking alcohol.
So what I would say about that is like we legislate. So it's the most obvious arena in which the law works to legislate morality is and historically has been the criminal law. But so you're totally right. Okay. But I'd also make clear that when we talk about legislating morality or even just legislating like a worldview, a political worldview, which might have moral components or whatever, that's what other aspects of the law do all the time as well. Right. So in other words, the Western liberal legalist approach to doing law, so, also like Anglo-American approach, right, is very centered on a particular idea of who is a proper subject of law, the autonomous individual, right? And who has legal rights and responsibilities, who gets to be able to use the law in order to vindicate their claims. And in other words, there's a certain standpoint, right, that the law takes that also has moral implications, but yet nothing so obvious as, the targeting of drugs and alcohol, for example.
That's a good place to ask you then, I think. What do you see as what do you think, Heidi, are your biggest perhaps frustrations with the limitations of that very system?
My goodness, that's a big question. I mean, so frustrations with the legal system. I mean, honestly, I really conceive of myself as right now, my personal intellectual project as trying to make people, like everyday people, as well as the students I'm training for, entry into global hierarchy, global systems of hierarchy and power reproduction. But anyway, so of actually just making them understand that basic fact. And the reason why that's so important, it's important, I think, across any field that it attends to the question of power in society generally, but, so philosophy, but law in particular is very, it's just extraordinarily good at constructing and narrating justifications for itself, right? So another
interesting, yeah.
Yeah, so the legal system we have, and again, broadly, across, let's just say across the West, we tell ourselves stories from an incredibly early age. Like, I don't know, if you take, in the US, you would take like civics class, like we have some version of that in Canada. I forget what it's called. I don't know. It did not make an impact on me at all. And I remember sitting there going, God, this is bullshit. Because they do this. So the way that this proceeds, there are so many different ways in which this proceeds, and some sub areas of law have their own as well, founding dominant narratives about the authority of the field and the structure. So it's not just like the law itself, like all of the subfields do as well, right? So you can tell one of these dominant narratives in any, like if you're doing tax, or if you're doing criminal law, if you're doing international law, whatever. But if you go into that, I don't know, what's it called? Do you have this in the UK? The equivalent of a civics class?
Well, I grew up in Ireland, so there's a version of it. I can't remember what it's called actually. I think it must be. I think it was called civics. I didn't get it, but no.
So,
no.
But you'll go in, and in Canada we we've had a constitution for many years, but we got the Canadian Charter of Rights and Freedoms in 1982, which was a big moment in shift in constitutional law in Canada and its relationship to Britain, and also its relationship to basically having, a written constitution that lays out fundamental rights and freedoms. So that changed the way we did law quite a bit in Canada. But in order to, that was recent. That was 1982. There's also the British North America Act, which is also our constitution, which is from the 19th century. Nobody puts that on the wall, right? But they put the Charter of Rights and Freedoms on the wall. And as this, what would a religious, like what would the Catholic Church have? What do you call these things? Like something you worship.
Deity, a god, an icon, a shibboleth.
Yeah, exactly. It's great. So shibboleth is a great word for it. So that's what we're doing. And then in the U.S. they have their have pictures of the Constitution everywhere and whatever. And it's a bit different in the UK because there's a written Constitution. But that is, we have her on our money too.
Oh yeah, of course, I forgot that. Yeah.
Oh, he's our head of state. So. So we have these narrative. In other words, that's the beginning of a narrative process of it's not wrong to say indoctrination, right, into an acceptance of the authority of the system that you're in. In other words, simply buying into the whatever version of the social contract that your society holds out to you.
So I mean, it's in regard to that. Then it's a case that the law is something that is, and correct me if I'm wrong here, it's espousing sort of dominant narratives or dominant stories about what a society is.
Absolutely. It's highly, I mean, it's a foundational, so constitutional moments, there's a real turn to constitutionalism over the last, say 25 years globally, right? Constitutional moments are taken extremely seriously. Especially like in newer transitional societies, for example, really revered and religious almost experiences. It's not wrong. I mean, it's all theological, this, in profound ways.
So I'm wondering how does that play out in generally, how does the theological play out in how you frame law?
Yeah, I mean, that's a big question. Do you mean, so there are different ways of thinking about that. I mean theological, I think, is a good way of explaining people's relationship to
That's all I mean.
Law,
that's all I mean.
Not like separation of church and state or the relationship of church and state. That's a different
question. The former, not the latter.
Exactly.
Yeah.
I think that's a separate question, but that's what people tend to talk about often in this room. And yeah, I mean, it's just like these documents are worshipped. Just think of the theater of the courtroom and compare that to the theater of the church, right? So you go into a courtroom. I was in a courtroom on Monday observing a trial, and you go in, the judges are in their robes. Like, they look like priests. Mm-hmm. Like, that's by design.
Yeah, they got really fluffy wigs over here.
Yeah, too. I know. I wore my friend's once for fun. It was good. But
me too.
Yes, of course.
You got to do it.
I know. And the lawyers do as well, and then they've got their various accoutrements, and then there's like clear signals of hierarchy and who gets to, who has power over who else and who can be reversed and whatever. And it's all, and if there's a profound way in which you can look at pieces of legislation, as like, codexes in some kind of medieval sense. And that's not, it's not really surprising. It just causes you to have to think down and like consider what's happening in front of you, right? Oh, and they're all like up on a pedestal, like literally on a dais and everything, the judge, and, and they're separated, the clergy separated from the people who are sitting in the back.
Yeah,
and
there's a dimension of the confessional there as well.
Well, this, of course, right? And Foucault and the whole thing. No, it's very, so they're procedurally and like structurally huge overlaps, but then also just like historically, like the Middle Ages preceded. This is like a horrifyingly simplistic version of what actually happened, but like the Middle Ages preceded a long struggle, as a centuries long struggle, over competing legal systems, right? So the Pope versus the kings,
right,
was the state. So, which required, of course, the church to have law as well. So it's not like the state was the first. The state was not the first entity to come up with law. It was the church, which far precedes the modern state.
So this isn't like natural law you're referring to?
Like canon law.
You're right, yeah, kind of Sharia law or something like that, yeah.
Tons of it.
Yeah.
Huge field.
Now, if you go to the, I think you spent some time in London, did you not?
I did. Yeah, I did a postdoc in London.
At SOAS, I think.
The British Academy postdoc, and I was based at SOAS. Yeah.
Yeah. So, I mean, I'm not sure if when you were here, you got to visit the Old Bailey in London, which is.
I haven't been to the Old Bailey. Yes.
Yeah, I mean, over the Old Bailey, there's a statue of a lady with scales and a blindfold. I think that's right. But that's the idea is that the law should be disinterested, it should be neutral, it should be impartial, and that there should be fair in some way. There should be equality before the law for all citizens, I guess. Now, how does that work with the elaboration of hierarchy that you're talking about? How can equality disrupt the hierarchy? I mean, or is that is just basically the $1 million question, isn't it?
Well, yeah. But even getting to that question, you see, takes quite a bit of groundwork, right? And this is great. So being able to show that, actually this is the question that we should be attending to is, not something that's in any way obvious and requires a lot of legwork. But, I mean, so basically fairness is a lovely term because, but you know what an even better question would be?
Go on.
How do we make sense of our desire for equality?
That's a much better question. How
do we make sense of our desire for equality within the strictures of the institutions in place? In other words, when we're claiming a desire for equality, we're claiming justice with a capital J, right? As though that should mean something to us. And the idea there, this is the genius of liberalism, in general, is to have these claims that we all agree, these normative impulses, a desire for equality and justice and fairness, right? To have these normative impulses that we all just agree upon, even though they are substantively completely empty, right? So you have to do work. You have to do concrete political work in order to fill up the content of justice or the content of equality. In other words, when the law talks about, everyone should be equal before the law, they don't mean everyone should be economically equal in the sense that there should be, a minimum or maximum wage.
No, they don't mean that.
That's categorically not what it means. Right? It means formal equality in a procedural mode and in a mode that attends to civil and political rights rather than economic and social rights.
Okay, so then if I look at sort of the British situation at the moment, so one of the big debates that we have here at the moment in the legal profession is that we have had successive governments. So we've had in 2010, we've had the Conservative Liberal coalition, and then we now have a Conservative DUP coalition, and we had a sort of a Conservative majority government. So we've had 3 successive Conservative governments basically, and they have imposed an economic austerity agenda, basically. So they've been cutting public services left, right, and centre.
I witnessed that. Yeah.
Yeah. But the consequences of that for the legal profession is that it means that barristers and lawyers who serve as what we call legal aid, so it's for giving people who have less money legal representation, because they're less funded, they have less access to the law, basically. So that's kind of, I guess, what you're talking about there. Beyond the postmodern interpretation of the law, you're talking about how we can substantively fill up the law with a different discourse, I guess.
Yeah.
Something beyond sort of the nice, naive word that is fairness. Is that right?
No, absolutely. So, I don't pursue postmodern methodology for its own, masturbatory sake.
Sorry.
A lot of people do.
You're the first person on the podcast to mention masturbation.
Well, I'm also here to talk about MeToo. It could get much worse, but there's.
I might possibly edit this without.
That's nothing. God. My free speech.
Of course. You can say what you want. Here, it's a podcast, So I mean, you're making the accusation of against postmodern that it's a bit that postmodern theorists can be somewhat masturbatory.
Yeah, obviously. I mean, so can a lot of things. But I was just joking. I mean, in other words, I actually don't. I think it would be irresponsible especially if you're in a field that deals explicitly with how power is parceled out in society. You can't do law without having some kind of normative or political project, even if it's very broadly conceived. So my normative and political project is that of a socialist who has a conception of what society should look like. That is more substantively justice-based, right? So I have an idea, socialists have an idea, as you know, is what justice means. And it has to mean much more than simply something like equality before the law. But yeah, I mean, I just want to point out, I don't know if your listenership is primarily like Irish and British, but,
American and British.
Okay, so the access to justice question that you mentioned I just wanted to really underline how bad the absolute gutting of the legal aid system in the UK is right now. How dire it is. And so if people are interested in sort of – because, it's very hard for the liberal legalists, the people who think that equality is about fairness and not economic equality.
So it's fairness to individuals, is that right? Or fairness to individual legal agents? Fairness
in the sense that, basically. It's ridiculous. It's completely ridiculous. And so that's for them what fairness would mean. And in some senses, neutrality, even the idea that the law should be neutral, in a strong sense, promotes the notion that we should let individuals be free to do as they choose, right? And we are obstructing so this is obvious, that we are obstructing an individual freedom, and individual agency, which is the bedrock of modern liberal legalism. Every time we start messing with government in ways that coerce people's ability to spend their entire paycheck without having to pay taxes or something like that. So it's important to point that out, because a lot of people just they have this crazy notion of public interest barristers as making lots of money.
That's not true.
Which is absolutely, I cannot say this strongly, that people just need to know this. It's so not true.
That's not true. No, yeah, I know barristers. Yeah, that they get very underpaid.
Awful. It's shameful. Basically, the expectation, the unstated, although culturally understandable, and this has to do with the hierarchy point, expectation in the UK is that if you're a barrister, you somehow have family money that you can just, get you through when the solicitor decides not to pay you, which happens a lot, or you don't get approved for legal aid, which often the approval process happens after the legal process has actually started and you've done tons of work.
Absolutely. And I mean, you might be up against someone from a richer social background who can afford, a legal firm with the best lawyers and who's got more money to have interns and all of this kind of thing.
Yeah. So I would just, if listeners are, I have to plug this colleague of mine who's great on this. If listeners are interested, check out Paul Kingsley Clark at Garden Court Chambers on the gutting of the legal system in the UK. But just because it is such an important issue.
Okay, yeah, I'll put it in the I'll put a link in the show notes.
Great.
So I mean, is what you're saying then, Heidi, that the only justice is economic justice?
I think it's hard to think. I think what I would say to that is that it might be hard. It would be hard to come up with a workable or defendable concepts of social justice before we have economic justice. Do you know what I mean? So right now we're putting the cart before the horse.
So you're saying we should concentrate on political questions of economic justice, and then we can look at how that's deployed in legal institutions and the legal profession.
Well, I mean, I think sort of. What I'm saying is, like, right now, when I say so perhaps what I was when I said social. Okay, let me see. So right now we have the ideology that we are operating within says that if the state ensures through its legal system the civil and political rights of individuals, then we will have social justice in some, like, that's what social justice means in some weird way, right? What I'm saying is that's relatively substanceless, because how in the world could you possibly ensure equal access to civil and political rights, even if they're articulated in terms of radical liberal individualism, which they are, if you don't have some sense of economic, I don't know if equality is the right word, but some sort of economic justice, as you said.
Okay, I think I'd largely agree with that, personally at least. But I think we've been talking for about 40 minutes and we haven't even got on to the main topic.
Sorry.
No, it's been great. It's been great. I love it. So my next question then
I was just being
is,
Canadian and apologizing.
You get that from the British, I guess, yeah?
Oh, yeah, fair. Okay.
I'm Irish, never apologise. You only do that in confession, basically. Yeah. I'll probably edit that out as well, Heidi. My freedom of speech to not be embarrassed. Okay, so the next question is, maybe we can look at one of the places where you where you kind of sort of drill down, so to speak, into sort of the legal practice, and that's your writings on sexual consent, right? So I'm trying to think how we can sort of link this up. I mean, well, is it the case for you, Heidi, that sexual consent is something that our understanding of sexual consent is something socially constructed. It changes and evolves over time.
Correct.
That must be okay.
Yes.
Got it in one.
Yeah.
But that must be uncomfortable for people. The idea that
also correct.
Yeah, I mean the idea that consent can change, or the giving and the withdrawing of consent.
You know what's so funny about that general, and that's actually a great way of positing, one of the ambiguities, let's say, that's involved in the current social climate, is this weird notion, like the tenacity with which the mainstream, and I say that in terms of the mainstream public, but also the mainstream, journalism and mainstream politicians and mainstream lawyers. So like just regular mainstream liberal society really is tenaciously holding on to this idea that somehow we didn't properly understand consent before November 2017 or October 2017.
So you're referring here to the MeToo movement?
Yes, exactly. And that we didn't understand consent. Consent is super important. You can't have social justice with regard to human sexuality without an understanding of consent, and that the reason they go a step further, this is extremely problematic because there's at least an implied causal connection or claim being made, right, between some kind of mythical lack of understanding of sexual consent before October 2017, and now a rediscovery. This kind of story narrative, justificatory narrative that the law pursues, and that also now society is pursuing is really interesting. Right now we have rediscovered consent, which was there all along, but we didn't really get it, right? And so in other words, what they're doing is they're pulling on the immutability or static quality of the notion of consent that you started your question with, right? At the same time as they are invoking the inherent mutability of consent. And there's some specific ways in which that second part is happening. One of them is very vocal calls, socially, politically, and legally, to move toward a different system of understanding what precisely constitutes sexual assault, that uses or deploys a concept of consent which is, let's say, affirmative. There's also an enthusiastic consent model. So in other words, consent is not just one thing, even though we're very strongly want to say it is. It can also be affirmative, right? It can also be enthusiastic. It can also be established with different burdens of proof attached, et cetera, et cetera. So there are different modalities in which we can roll out. Does that make sense? So it's a weird.
Yes.
They're speaking out of both sides of their mouth at the one time.
Right. Yeah. So when you say they, this is people in the MeToo movement.
So I think the they is the MeToo movement people, but also this is I would say the orthodox view within general liberal progressive society in general.
Okay. So and what you're calling for, I think, is put in its most simplest formulation, is you're calling for, I guess, a richer, more nuanced account of consent, one that incorporates affirmative, enthusiastic consent and even negative consent.
I don't know. What would you mean by negative consent?
Yeah.
What do you mean? People. Go ahead.
Like people could be coerced into consenting. I can imagine a situation like that happening.
Oh, just an absence of consent. Yeah, sure. Well, the legal. If we're to speak, and the legal and social question, these questions are not separate, even though many people would want to make them separate. So a lot of Me Tooers will say, I'll say, I start asking questions that sound legalistic, and I understand that causes a certain reaction in people, and they will respond saying, look, we don't care about the law. What we care about is this is a movement for social change. This is a movement about shifting the culture, shifting rape culture, in scare quotes, right, toward consent culture. And my response to that is, yeah, but what do you think the law, why do we have law? Because it constructs what we think of as culturally and socially acceptable behavior in society. In other words, culture and law are co-produced. This is a very basic postmodern point as well, right? So, and this all to say that I was about to answer your question by speaking from a legal standpoint, and then people would be listening and say, we don't care about the law, we care about society, and I'm saying that's an untenable statement. So the legal way of thinking about that, the legal question always in a sexual assault case, you mentioned negative consent, the legal question is, the broad legal question would be whether or not consent to the activity in question was present or absent. So that's the basic question.
And that's what people try to establish in a courtroom in, say, I don't know, if someone's being prosecuted for sexual violence or something.
Yeah, I mean, obviously all of the elements of the offense have to be proved, but the presence or absence. But the question often will turn on the presence or absence of consent. Yeah. I mean, if you can't prove if there is if there's reasonable doubt about the fact that two people were even in the same room together, that would be dispositive. But when you get to the question of consent, that's whether activity was consensual or not is the key question.
Right, and you think, and you're trying to articulate a richer notion of consent. What would that entail?
Well, I don't know. I mean, I'm not actually, so I don't think I'm doing that. I think, so let me try and reconstruct that and see if this makes sense to you. I am doing several things. One of them is a critical engagement with the notion of consent as either a necessary or useful way of thinking through the kind of social, or rather the kind of sexual activity that society wants to promote and sanction, right, in a positive sense. So I think it's far from obvious that consent can do very much in helping us, quote unquote, solve the problem of the scourge of sexual assault, which is obviously a problem.
I understand.
You know what I mean? And I don't think that's a straightforward proposition. I think it's an objectionable position. So I actually, somebody who would be trying to, so I am trying to complexify and add nuance and texture and all of that, but not because I'm interested in doing a law reform project. You see my point?
I think so. So I think what you're saying is that, well, I mean, I think it's almost like you're saying, Heidi, that like consent is just a very, very small part of this the problem of sexual violence and how sexual violence is framed legally and how sexual violence is framed economically and politically, and that
absolutely
at the same time, I guess where you're critical of, say, the MeToo movement, and I want to get this right, is that you're saying they're overemphasizing the role of consent on that. Would that be
absolutely.
Right?
Totally. Because it's a very easy thing to turn to, you know. So, and it's also an easy. It has become an easy slogan, you know. So if you Google Me Too, right? I'm going to do this now just for shits and giggles. If you Google Me Too and go to the images section, you see the Me Too hashtag, but you also see things like project consent. Consent means this. Consent means that. We are for consent or whatever. Like there are lots of slogans about consent as an anecdote in some sense to whatever, like, extremely complicated gendered economic story we have about sexual assault.
I think one of the things that I was picking up from your writings on this, and I think in particular your article in Aeon, and again I'll put up a link to it, is that one of the things that you have one of the problems with an aspect of the Me Too movement that you have is that there's even a problem with the epistemology of it, I think.
Yes.
Which is the idea. Yeah, so it's kind of the idea that we're taking opinion as truth. Right, that our opinion ought to be taken as truth. Mm-hmm. Is that right? Is that what the Me Too movement are doing?
Yeah, so that's a really interesting question. Yes, and you're right. There are really so many angles. Right? Epistemology is absolutely one of them.
Yeah, I mean, it's in the title. Like Me Too, it's about a subjective expression, I guess.
Opinion is fact, and then I think there is a useful distinction between opinion and personal experience. Right. So I think Me Too is not necessarily, although opinion does come into it, right? Because part of my argument is that Me Too has become an ideology. Me Too-ism is like a saying, I think. So I do think it's an ideology, but the general proposition would be, and this is so if you were to consider this in explicitly legal terms, this is an evidentiary argument, and it's not wholly without merit, but we need to understand the structure of the argument space that we're working in. So, and Jeannie Suk, who's also at Harvard Law, she writes in the New Yorker, and she's done, I think she wrote this in a piece she had written about the Cosby trial. So I'm just taking this, lifting this directly from her, where she said something like the Me Too claim is a direct evidentiary claim in the sense that if you're claiming something that you say happened to you happened to me too, that makes it factually more likely that the thing happened to the both of us. Do you know what I mean? So I mean that's one way in which the law aside. Now there are lots of problems epistemologically with the law of evidence, right? But the idea is that if you can show that the same thing happened to multiple people, it's more likely that the thing happened. In other words, that there's a social problem with sexual assault. I don't think that's Is that a problem for you as a philosopher?
No, I don't think so.
Yeah.
I don't think that would be controversial. I mean, the big case in Britain was the Savile case. I'm not sure if you followed it when you were here, and it really was a case that there were so many people offering testimony.
Yes.
That it it was like there was a tipping point where I said, oh yeah, this. I mean, why would so many people make up a collective lie about this? Is clearly true.
No, absolutely. So one needs to be, and thank you for being so painstaking in your pursuit of clarity with the issues, because these claims, in order to have because then someone turns to you, a feminist, for example, says, how can you call yourself a feminist? Or even a leftist, right? So I'll get called like an MRA person, right? Like I'm a hidden,
Sorry, what is MRA?
Men's rights activist. You know these people?
Oh, yeah, wow. Okay.
Yeah, they'll be
right.
Yeah, the idea is that I'm some kind of like embedded Trojan horse MRA
of the patriarchy.
Yeah, it's just like completely absurd. But people believe that, and I think that in some sense that makes sense, because the evidentiary argument has something to it, right? Now, what's problem?
For the reasons you outlined.
Exactly.
Yeah.
So that's uncontroversial from your perspective as a philosopher, and my perspective from just a judicial perspective. That makes sense. Now, where it becomes controversial, however, is the traveling, right? So this evidentiary argument has been picked up and transported into the realm of general cultural production, and mainly through the vehicle of social media. Okay. Now, the structure of the argument still makes sense. The structure of the evidentiary argument still makes sense. Where it starts to fall apart, though, is that we don't have any way, actually, of managing the various testimonies that are put into the MeToo soup, right? Or I'll use the word policing again, ironically, right? Or we don't have any way of managing those testimonies. We don't have any way of policing them for accuracy. Okay. And accuracy doesn't just mean, is she lying? That's too grotesque and what's the word? It's just simple. It's just dumb, right? So of course, very few women are going to make up stories out of whole cloth about sexual assault. Of course, that's true. I would never say that that's, I mean, of course, everyone makes up stories all the time, but of course, that's not plausible. But there are various other things that will enter into the process of testimony accumulation or and distribution that should give us pause about how we assess the social and political and legal meaning that we should attach to X, Y, or Z MeToo contribution, right? Does that make sense? Do you follow?
Yes.
Right.
Yep,
right.
Yep.
So those things could be like, right. So you don't have to say that someone's necessarily lying. You'd want to assess exactly what the claim being made is. So a lot of the, whether or not it pulls on actual lack of consent, or whether it pulls on, more socially structural lacks of consent. In other words, whether, formally, so an example of this would be formally, whether she said no or clearly indicated no through words or actions, in other words, or whether we want to actually say the power differentials at play in X or Y workplace made it such that actually she was incapable of ever truly consenting. Do you see how those claims are like radically different? And that's just one example. Okay. So those claims are radically different claims, and we need to have this is my own desire would be to have a really frank, and this is hard work. I understand it's hard for society to talk about sex in a way that makes any sense. That's a big ask. I get it.
Well, yeah, I mean, it doesn't lend itself to the categorization, does it? By definition,
it's a really big ask, but I think it's really important. So the only good thing about the movement, it's not a movement, but the only good thing about it is that it could potentially allow us to start doing that. It hasn't to date, so I'm not hugely hopeful, but I mean, I consider my work as part of that. So, in other words, in order to, you know, we cannot just, go, so someone says, so, for example, could Monica Lewinsky consent to the activity that took place between her and President Clinton, right? So, Lewinsky had historically always claimed that it was consensual. Okay, what happened was consensual. Post MeToo, she has now claimed, I believe in Vanity Fair, that it was not consensual because of the extreme power differential. Now, I have my own opinions about normatively about what sorts of attitudes we should take to that, but I don't need to even state my opinion here, because all I want to point out is that it's a really big open question socially about whether we should start sanctioning, either from the point of employment law or human rights law or, you know, whatever, not just criminal law, like all these other areas of law that actually are being called into play, if we should start sanctioning an understanding of consent that allows us, as, you know, a quasi-neutral third party, so-called neutral third parties, right, to act as judge and jury and say that now it doesn't matter what Lewinsky thought at the time. What matters is the structural, the level of either economic power, age, whatever disparity, right? Power disparity is present between the parties, and that all of that requires like an affirmative theory of what power imbalance means. Right?
Yeah, so you need to do more work than just talk about consent.
Yeah, we need to talk about, like, okay, when we say all this is about power imbalance and therefore there was no consent, we haven't done any of the work that, you know, not right thinking, but well thinking people are trying to think well, in other words, authentically about this stuff. We haven't done any of that work. And the moment somebody like me says we need to do the work, then I'm a rape apologist.
What you're saying just tends to it shows the emotive side of the issue as well, which is really, really hard to get past. I mean, that seems to me to be one of the driving forces of expressions of Me Too, which is that, and tell me what you think about this, it's, you know, even set aside even the thing about consent. I mean, I don't think, as you say, sort of a well-thinking person would say that all claims about sexual violence should be taken as truth, but instead that should at least be taken seriously.
Sure, of course. Yes.
Yeah, and I think that's a driving force of the Me Too. Well, you say it's not a movement, yeah.
I don't think it is.
Why do you say? Can you say why?
Oh God, I mean, for several reasons. I think that's a great example that you just gave, right? So and this relates to the question of why it isn't a movement. Because of the hashtagification of the whole thing, right?
Do you think it's commodified?
Yes. So, but I mean, that's one reason. So, in other words, there's this the hashtag believe women. I mean, this is like almost fascist in some way, like, because it's asking you to suspend like any disbelief or judgment or like
skepticism.
Yeah, like of any kind. And then they'll be like, well, so the one response to that is, well, we don't really mean believe women, but they do actually, and it's not a call to take sex assault seriously. It's a very different thing. Of course, we should take sexual assault allegations seriously, but you know, take sexual assault seriously wouldn't trend, or it wouldn't get clicks or whatever. So there's a huge amount of commodification going on. I mean, I don't even know how to do this research. Somebody who works in some other field who's able to do this would, like, I should get some of my business school colleagues or something to do this. Like, where if you could like try and figure out how much, like just some rough estimate of how much money has actually been made, off on the back, as it were, or off the back of Me Too. So it's commodified. It's commodified. Number one, it's undifferentiated. So it's, in other words, the commodification operates along standard capitalist logic, which leftists are supposed to be uncomfortable with. Right.
So what do you mean by that?
Because it's just operating like it's just a fucking. Sorry, you can take out my swearing. It's another.
not a chance.
That's okay. You can leave it. And so it becomes. So capitalism will relentlessly create markets, and it has been radically successful in creating one here, right?
Okay, so can I just to bring it all back to where we talked at the beginning then, and sort of your sort of criticisms of postmodernism. Do you think the Me Too movement is postmodern?
So the ways in which postmodernism is problematic. Yes. So I had actually written down two ways in which postmodern is problematic. We only talked about one, in the sense that it neglects real effects. So the standard criticism of postmodernism would be, one of the standard criticisms would be that it ignores real effects. So you're saying we could say one of the standard criticisms of Me Too is that it ignores actual effects in the world. Yes. So I think that broadly speaking, that's true in the sense that it is calling for change and reform on a policy level. And this point is actually really important, the policy aspect to all of this. It's calling for change and reform on a policy level without any real attention exactly to this. So you've set that up really well. Thank you. Exactly to the question of who will win and who will lose in society if we adopt the sorts of policy reforms, and as well as affective dispositions towards the problem as it is constructed by the hashtag. I think that's true.
Do you think there's like a sort of degree of homogeneity about
yes.
how it's presented, at least online and social media?
Yeah, I mean, one of the other, I just want to get this on the table and see what you think about this, as you're a great person to have on the line about this, because the other standard or common critique of postmodernism is that it comes from the moral realists, right? So, and I've had like extensive fights with some philosopher at Rutgers over my lack of commitment to moral realism.
Oh yeah, I mean it's how could you?
Yeah, like what? You don't? And I was like, yeah. So
when you say moral realism, you mean like that good is objective and
that right and wrong are things in the world, right?
Okay.
That morality is a thing, so there is a right answer, and he said to me actually on Twitter, which is actually a good observation. He's like, well, you sound like somebody who may be a realist, but then believes that we, given the limitations of like human epistemological modes of operating in the world, we're unable to actually access it. And I was like, yeah, I'm comfortable with that. But if you're gonna say that, then it doesn't matter whether there's moral realism or not, because we'll never know what morals are real, because you'll never be able to discover them. So whatever, but I think, that's important here too, because Me Too is claiming, is a basic, in some sense, like a moral realist project. And so all of this was in the context of something I had said about consent and its frailty, and his moral realist response, was triggered by my Me Too thing, right? So, so that's really interesting framing. I think Me Too is fallible on all those levels.
Where do you see any positive inroads in this debate, or is there anything that's given you encouragement, or is there anything that you've gone, that's a really good example of what I'm trying to do, and it's a really good example of, as a socialist, making the world a better place?
Yeah. So I will give you an example. There are a couple. Some people might be surprised, but there's an example, and I'm going to be, but people will hate this because so funny. You can't win on anything. So my example is Brett Kavanaugh. Okay, so you've been following, I'm sure, even just tangentially the headlines about
yes.
the Me Too. Should I reprise just very briefly that there?
Briefly, yes. Not everybody might have heard of it.
So the United States is going through the confirmation process of Supreme Court nominee Brett Kavanaugh, who's obviously a Trump nominee. They're trying to, and the effort is to make the court more conservative because it's quite split now. This would tip it toward the conservative agenda, whatever. And the real problem there is that, look, appointments, this is absurd, but judicial appointments to the Supreme Court are, like lifetime appointments. And the guy's like 50, so he can be there for the next 50 years. And he's a complete asshole.
Is that your
there's no other way to say it. It's my professional opinion that Brett Kavanaugh is an asshole. So I'm very comfortable saying he's an asshole because, he's against choice and against everything that any liberal, even many conservatives in Canada and the UK would find him abhorrent, and indeed many in the Republican Party in the US do as well. But anyway, so looks like he's set. The confirmation hearings were last week. Looks like the week before last. Looks like he's set to get confirmed. It was supposed to be this week. And then there's a woman who alleges she is her name is Dr. Ford. I think she lives in California, and she's a psychologist, interestingly. And she alleges that he assaulted her in high school. And now there's a whole bunch of other details people might be interested in if they want to read it. She ended up actually doing a polygraph test. So there's significant indicators of the reliability of this claim. She's also ready to submit to questioning in the Senate. She's going to give testimony in the Senate. There's a bit of a question of the timeline of that right now. But the larger point is none of this would have been possible. Not that it wouldn't have been possible because we had Anita Hill and Clarence Thomas and the sexual assault allegations in the 90s with his confirmation. But the likelihood of such an allegation in the wake of this Me Too thing is higher now because of Me Too. And it's getting much more social attention because of Me Too. And this is a Me Too story. So people are just saying this is in the name of Me Too, and I don't care. Great. I think Me Too is an ideology and is overall not good for society. But if we can I will do anything I would want Americans who are in a position, anyone in America who's in a position to do anything to take down this guy, short of physical violence, should do that. So from a tactical perspective, right. I don't care if overall Me Too is bad. I'm very willing to be extremely critical of Me Too and at the same time say, yes, absolutely use it to take down this animal. Well, it can also go, the problem is this, it can also be used by conservatives to take down liberals, etc. But in this instance, I'm very comfortable resorting to it.
So you use the resources you have in your arsenal, basically.
Yes, exactly. But I don't think that's a very standard left.
I think so. Yeah, I think so. I mean, you make your interventions where you can, and you do your best with the tools available to you to improve the material conditions of the world. I guess would be the sort of the socialist perspective. Yeah.
That is optimistic. The idea that that's what I'm saying. This is wonderful. The idea that we now are more able than we were previously.
I see.
To take down a political opponent is a very good thing from a socialist perspective.
Heidi Matthews, thank you very much.
Thank you so much. It's been very fun.
Come on, Jimmy. Who are you going to fight against when this balloon of yours goes up?
Forces of anarchy, wreckers of law and order.
See?
Communists, Maoists, Trotskyists, Neo-Trotskyists, Crypto-Trotskyists, union leaders, communist union leaders.
See?
Atheists, agnostics, Long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government, love.